Hello and welcome to this short presentation I'm giving about being an expert witness. Who would be one? This is really intended for people who've got little or no experience of being an expert witness, or who are just starting out, or who want to know more about doing expert witness work. It's based on my personal experience of expert witness work. I do not pretend to know everything. I'm not the most experienced or the most knowledgeable expert witness, but I do have quite a good amount of experience that I hope you'll find useful. I am professionally an environmental consultant with an academic background in air pollution and plant ecophysiology, but in recent years I have been getting involved in a lot of private nuisance litigation claims, mostly relating to either odour or particularly Japanese knotweed, where I do have quite a lot of experience. And like many technical consultants, I am mostly doing technical work. So expert witness work is actually a pretty small part of what I do, although it has been increasing quite a bit in recent years. So what are the duties of an expert witness? Well, very importantly, the first one there is that you are impartial. Your duty is to the court. You cannot be swayed, or you should not be swayed by what your client is trying to achieve in their claim or defence. You need to understand the legal process. You have some pretty onerous legal obligations, the consequences of which can be significant. You need to know about that, and we'll come on to that. Your reports and your evidence that you give orally in court, if you get that far, needs to be factual, evidence-based evidence. Facts can be actual truths, or they can be assumed from your experience, but importantly, you need to have a clear logical progression that the judge and the other people in the court can follow to see how you arrived at the opinions you give in your expert witness reports and oral evidence. Those last three bits, the expert declaration, statement of truth, and that you're bound by an oath or affirmation when you're in court, that's really important. It highlights the fact that you are in an important setting that's different to maybe the environment that you might be producing technical reports for clients. If you tell fibs or you don't respect the court, then you could be accused or found guilty of perjury or contempt, and that is a big deal. So the general process of being an expert witness, this is just the outline of the process in a civil claim. It's a fairly straightforward process. Note there's a lot of points in there, and settlement in a case like this can happen at any one of those points. So it can be quite long, drawn-out process. And the fact that there are a lot of stages there means that you might not necessarily get to the end, which is attendance in court. And that is a problem because a lot of experts don't ever actually get tested in court, which is the important place, really. You've got to be on top of your game if you get that far. So this first step is you get your instructions from the solicitor. Solicitors decide that they need expert evidence from an expert opinion from an expert witness. So you're supplied with all the appropriate documents, the evidence for the trial, for the case. You might need to do a site survey, take measurements, visit the site. Then from all that information, you compile your report. The other side, their expert will sometimes, if there's two experts, you're not a single joint expert, they'll produce a report, and then you'll compare them. And then in doing that, you might need to meet the other expert to look at where you agree and where you disagree. And where you disagree, you need to show that in a joint statement. And it's those points that you disagree on that will then be tested at court, and that's where you get cross-examined by a clever barrister. So common mistakes of poor experts. The first thing is that you're not properly briefed, and that's more common than it sounds. In my experience, solicitors are very busy people with big caseloads, and quite often I don't get complete instructions. You need to recognise that if that's the case and ask for better instructions. Another one is that a lot of poor experts will use broad brush statements and unsupported generalisations in their evidence. It's very tempting, particularly as an intelligent technical person who knows what you're talking about, has got a lot of experience. It's very tempting for you to leap to conclusions based on what you think might be obvious. You need to be careful and be transparent and show how you have arrived at your opinions, and that's not easy. It's quite a difficult skill, really. If you're all prepared for oral evidence, as I said before, a lot of experts, they won't end up in court. They'll have done their report, done a great job, agreed everything with the other side, and they don't end up in court. So if you don't ever get that much experience in court, you can be all prepared for it if you do get that far. So if you're arrogant, that's not going to go down well. Similarly, if you're lacking confidence, then you can come across quite poorly, and your opinion might not be trusted, and you also might get hammered by the opposing counsel. However, by far the most common mistake that I see experts with little experience make is where they tell their clients what they think their clients want to hear and not what their clients need to know. So what I mean by that is that if a client, a solicitor, wants an expert to provide an opinion to give them an idea of how successful their case might be, that an expert might give them information that fits with what they want to hear and supports their case. But what they really need to know is it a good case? And I see that happen quite a lot, where even an opinion is given to a solicitor that's weak, and that when they come up against a decent opposing expert witness, that they get hammered. So the potential outcomes for poor experts. Well, if you have given an opinion that has taken a case further along the process than it ought to have got because it's a weak case, then the court could slap you with a wasted cost order, and that could be quite expensive if you've wasted a lot of lawyers' time. If you are quite flaky, you don't come across well in the court, you can't argue your opinion, then your report could be withdrawn, your evidence could be withdrawn, and your opinion is made inadmissible. Again, that's a waste of time. If you are found to have fibbed, and there's quite a few cases, examples of where that's happened, where an expert has either outright lied or has changed something in the report, and it's to fit with what their client wants rather than what's true, that you can go to jail or be fined. And similarly, contempt of court. Example, I suppose you could arguing with the judge, maybe. And then similar to wasted cost order, if you are providing evidence to your solicitors that causes them to proceed with a claim, and then it transpires that you were negligent in giving the information that you gave, and there isn't a case, then you could have a negligence claim slapped against you for the costs incurred by the solicitors in pursuing with that case. Right, well, that's it. Very quick outline of expert witness work. Thank you very much for listening, and please check us out on our website. There's lots of information on there, our other YouTube channel, and on Twitter. Thanks very much.